Welcome to the DeWitt Law Review on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Remember, the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For legal advice, you can call the DeWitt Law Firm anytime at 1-800-DeWitt-Law. That's 1-800-DeWitt-Law, or you can visit DeWittLaw.com. If you want to get your legal questions answered on this show, send those questions to ask@DeWittLaw.com. That's ask@DeWittLaw.com. We're here every Sunday morning at 10 a.m. We talk about Florida's legal issues and how they affect you. I'm John Bustecker, and across from me is the man, the myth, the legend, attorney Mo DeWitt of the DeWitt Law Firm. Good morning, Mo.
Good morning, John. How are you doing?
I'm fantastic. This is the first time I've been hosting the DeWitt Law Review.
Yeah, we appreciate you stepping into those big shoes to host it for us.
I should say co-hosting because you are the host. I'm just sort of here.
I'm the host. I'm here as well.
Okay, all right.
But most importantly, we're here to answer the listeners' questions.
That's true. That's true. First time host, long time listener, right over here.
There you go. There you go.
So let's get right into it. Since we're here, it's Sunday morning. You're probably drinking your coffee right now, listening to the show. Maybe you're driving somewhere, headed to breakfast, headed to brunch. But I know in the past you've talked a little bit about Florida and the alimony reform bills that have been going through the Senate and the House. I believe they're maybe close to being signed. Maybe they've been signed by this point. Tell me a little bit about this.
Yeah, so we touched on it last week. There was an alimony reform bill that went through the legislature that was passed, but the governor still has to sign it. So, if you've listened to the show for a while, this is probably, I think it's the third time, it might be the fourth time that an alimony reform bill has gone through the legislature. Last year, they had one that also was passed, but the governor ultimately ended up vetoing that. And the big reason, or the main reason, I should say, why he vetoed it was it had a retroactive aspect to it, meaning that if it was approved, anyone who was paying permanent alimony, the permanent alimony was going to be wiped out. Mm-hmm. And so that infringed on the contracts clause under the Constitution. So he believed it was unconstitutional because basically if you get a divorce and you have a settlement agreement and that settlement agreement provides for permanent alimony, that's a contract, and the government can't come in and infringe upon two private parties' rights to contract.
Can you explain a little bit what permanent alimony is? Is it basically what I think? Like if I'm married 1 year, I could get alimony for the rest of my life?
So that's actually a great question because that is a bit of a misnomer. So permanent alimony in the state of Florida, if you're married for 17 years or longer, there's a presumption in favor of permanent alimony. Doesn't mean it's automatic, but there's a strong presumption in favor of permanent alimony. And permanent alimony basically means alimony until you retire at a reasonable retirement age for your profession. So I would say, like, if you're an NBA player, you're not going to be playing till you're 65, right? I mean, a 40-year-old retiring in the NBA, that's probably a pretty long career in the NBA.
How about an attorney? When do they retire?
We never get to retire. We just die at our desk here. So, they have to look at a reasonable retirement age. But the problem was you have to go back and modify. So you basically have to file a new lawsuit in court asking to modify or eliminate the alimony. It's basically a second divorce case all over again. I've told these stories before, but I've had people who haven't seen their spouse in 20, 30 years.
Still married that whole time?
Well, no, they're divorced now,
okay.
But they just haven't seen each other in that long. Their kids have grown up. Maybe they got married young or whatever it may be. And, now they're back in court and they're like, who is this person? Who is, they barely recognize each other at that point. So that was part of the problem is you have to go back to court. The other issue is the court can consider, passive income as part of a modification. So if you've done well in your career and you have, substantial retirement savings, and that's even if you're not drawing off of it, if it's generating a good return, they can use that return on the investment as quote unquote income to you for still calculating the modification. Mm-hmm. So your alimony in those situations may be reduced, but may not be eliminated.
You said this bill is kind of a version of this bill has gone up several times.
Yeah.
Were there certain groups that were against it?
Well, before there was two main provisions that caused some problems with it. One was that there was a presumption placed in the bill for 50-50 time sharing or child custody. We call it time sharing in Florida. And so my understanding is, again, I'm not in the legislature, but my understanding is that one of the legislators had a nasty divorce, and so he wanted to put that 50-50 presumption in there based on his own personal circumstances.
Oh, well, that doesn't seem fair.
Well,
for him, I mean, just to do a whole bill based on your circumstance.
Well, I think everybody, they draw on their own life experience when they're trying to draft these things and come up with stuff. And so, there was a lot of pushback against that because basically, instead of having a standard where it's the best interest of the child, the court started that it's always the best interest to split it 50-50, then you have to work your way backwards. So it's just the way the presumption was. And, unless you've kind of been through a divorce, it may not make a whole lot of sense there. But so there was a lot of pushback against that. The other one that people were really opposed to, and the family law section of the bar was opposed to this for a number of years as well, was the retroactive aspect, because it just creates such chaos with every single divorce case that has permanent alimony in the state of Florida.
Oh, yeah, I can imagine.
If you're going to go back and eliminate that. So what does that even, in the last bill, we said the one that was passed last year that was ultimately vetoed, my analysis on that, it was really, they wrote it and then it was negotiated and then they kind of just pushed through this last minute bill that really made no sense, because one of the big problems with it was it didn't say what happened if you had permanent alimony. It said it eliminated it, it retroactively eliminated it, but it didn't say what happened to those people. So let's say you were awarded permanent alimony, but you were just awarded it 6 months ago. It's still permanent alimony. It's now been eliminated, but what's it replaced with? How do you, so there was going to be a lot of court cases over, all right, now basically we have to relitigate the alimony portion of the divorce to find out how long does my alimony last for.
So this new bill that got passed, waiting to be signed, that fixed that, what you just described?
So this one doesn't have the retroactive aspect to it. So it won't be retroactively applied to all cases. It will just be cases that are filed or pending. I think it's July 1.
1st. Yeah, I think it's July 1
forward. So in those cases, the court, as part of the divorce decree, will address that situation. Will address how do we handle the alimony, what are we going to do with it, and how long is it awarded. As well as this bill does have some guidelines. It's not, I wouldn't say it's quite a mathematical calculation, but it says, if you're married this long, then your alimony can be between these years and those years, basically. It gives you some guidelines as far as how long it's going to be.
I know the bill is long. It's a long bill. I glanced at it before we started the show, and the permanent alimony is the biggest thing that's being changed. Is there anything else in the bill that's sort of a big change or will be a big change if and when it's signed?
Yeah, I mean, there's some other little stuff in there. Honestly, a lot of it that they state in there as almost new law was really already a part of the case law. For instance, they say that you have to show special circumstances to award life insurance to secure an alimony obligation. Well, if you actually looked at the case law, that's what the case law already said. This bill does allow for lump sum alimony lump sum alimony in place of permanent alimony or durational alimony, which before you had to, again, show special circumstances for that. You basically had to show that the person was just going to not pay the alimony, that they had a history of saying I wasn't going to pay alimony or avoiding alimony. In those cases, the court could award lump sum alimony, but otherwise lump sum really wasn't allowed. So they went back and they allowed that now. One thing that they added in there that's a little peculiar to me is it says that the court can consider the financial consequences of adultery. And so, as divorce attorneys, when someone comes to us and they say, oh, my spouse has, committed adultery, has been cheating on me, typically, we've always said, well, that's really irrelevant, except if there's dissipation of marital assets, which basically means they're taking the person they were cheating on you with and buying, expensive jewelry or going on expensive vacations. Basically, that was money from the marital estate. So you can pull that money back in and you can split it 50-50 because that's the way it was supposed to be split. Well, I assume that's what this means, that they're just basically recodifying that, because that's what the case law has said over the years. I'm assuming they're just recodifying that as part of the statute. But when they say, as far as, they leave it broad, they say the financial consequences. Well, what does that really mean? Are people now going to try to argue, oh, I was this affair made me an emotional wreck and I couldn't work, and that's a financial consequence?
Okay.
So I think
you're right. I mean, there's a lot of interpretation of that.
Yeah, I mean, I think that's a little dangerous there if they don't. I'm sure case law will clarify it over the years, but what always happens is when a new law like this is passed, it will take 2 or 3 years before it gets to the appellate courts. And the appellate courts are the ones who make case law in the state of Florida. So, when you file for a divorce, if you filed, let's say on June or July 1, it might take you a year to get to trial. That's probably a fast period of time, frankly. And then let's say you didn't like the result of trial. Well, then you can appeal. An appeal might take another year or two. So it's going to be 2 or 3 years before the appellate court actually issues an opinion on that case. And that's what the case law is. So there's going to be still some uncertainty between assuming that the governor signs off on this bill, on some of those provisions until there's new case law made under this current statute.
So you had said at the beginning of this that this governor and former Governor Scott vetoed this bill, or a version of this bill.
Right.
What do you think the chances are that Governor DeSantis will sign this version?
Well, like I said, the two controversial provisions in the other bill were the presumption for the 50-50 or equal time sharing and the retroactive aspect of the alimony bill. And frankly, when those were both in the bill last year, I said the legislature probably won't pass it. They actually did pass it, but the governor ultimately vetoed it. Now, this year, both of those provisions have been removed. So I think that eliminates a lot of the controversy surrounding the bill. So I would suspect, this is pure speculation, but I would suspect that the governor will ultimately sign this bill and it will become law, unless there's just something in there that he doesn't like for some other reason that really hasn't been an issue in years past, which could certainly be the case. But they I always said if they want to get this through, those are the two provisions they have to eliminate. It's just never going to become law with those two provisions because there's too many issues surrounding them.
And I know it passed both houses, both the House and the Senate, by a large majority. It wasn't like it was 50-50.
No, but also, I think there's a large majority in favor of one side in the legislature right now, too. Yeah. So that also kind of speaks to the votes on that. There were still some people who voted against it, obviously. And I don't know their specific reasons for voting against it, but ultimately, I think it has a pretty good chance of being signed by the governor and becoming law. And so, what that basically means is that, if you're going through a divorce right now, this could affect you if your divorce is not finalized prior to July 1. And if you're currently paying permanent alimony and you want to file a modification, this could also have an impact on that as well, because it does, again, re-outline some of the provisions. It's not drastically different than our current modification statute, but it kind of clarifies some of the points that, again, case law have developed over the years as far as, what a modification looks like, when you could file a modification, and then, what is reasonable as far as, eliminating permanent alimony and the years and things like that.
I know this bill went to the governor's desk a week and a few days ago. So he doesn't have much time to decide, because there is a certain amount of time a bill has before it needs to be signed, or else it is ultimately, I guess, I don't know if the term is pocket veto, but if he doesn't sign it, it essentially dies.
Yeah. So, as of right now, he has not signed it yet. I assume that we'll probably hear something on it next week. And then, next Sunday, we'll certainly follow up with you guys and give you an update there and show you what that looks like and ultimately how it's going to impact you if you're going through a divorce or thinking about going through a divorce.
So maybe we can speculate a tiny bit on that, Mo. Let's say the governor does sign it. Let's say he signs it tomorrow, Monday morning.
Okay.
What would you tell your clients? Would you say we need to get something done before July 1st, or does it just depend on the case?
It's going to depend on the case, and it depends what side of the case you're on, certainly. So if you're currently going through a divorce, and let's say you're hoping to receive permanent alimony, well, then you want to get that case finished before July 1st. If you're on the other side of the case where you may be paying permanent alimony, obviously you want the case finished after July 1st. So it depends what side of the coin you're on, essentially. But realistically speaking, given that it's May now, that's May, it's probably pretty hard to control the timeline of your divorce anyway. So this is more going to be how it's going to impact people who are thinking about a divorce.
All right, Mo, we got to take a quick break. We're not going anywhere here. So if you got questions, you send them in. We're answering them here on the DeWitt Law Review. Send those questions to ask@dewittlaw.com. That's ask@dewittlaw.com. We are here every Sunday talking to Mo DeWitt of the DeWitt Law Firm. We'll see you in a minute.
If you're injured in an accident, there's a number of different types of compensation that you can receive for your injuries. Of course, the most common one is probably pain and suffering. The compensation you receive for the pain and the suffering that you went through as part of that accident. But you can also receive compensation for things like lost wages, for your medical bills, your out-of-pocket expenses, You can also receive compensation for your future medical expenses, the expenses that you're going to have to lay out in the future to get the ongoing care that you need. There's also other types of compensation that you may be entitled to if there's a loss of enjoyment of life or a loss of companionship. So it's important that you talk to an experienced attorney who can discuss the different types of compensation that you may be entitled to depending on your life circumstances and the type of injury that you sustained.
Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. My name is John Bustegger, and I am here with Mo DeWitt of the DeWitt Law Firm. Mo is answering your legal questions just like he does every Sunday here on WDBO. If you have legal questions, send them to ask@dewittlaw.com. That's ask@dewittlaw.com. You can also call the DeWitt Law Firm at 1-800-DeWitt-Law or visit us online at dewittlaw.com. Mo, I got a question for you.
All right, let's do it.
Are you ready?
I'm always ready.
All of our listeners are ready for the question portion of this show. And so here we go.
All right.
We got this one the other day. It says, "Good morning. I am currently separated from my husband and in the process of getting a divorce. When we separated, it was agreed that he would take over the payments on the car that he is currently driving, which is only in my name. I just received information that he has not been making payments as promised, and not only do I owe the amount due, but it has also affected my credit drastically. When I asked him about it, he told me that he will not be making the payments. My question is, can I take the car away from him since he has not been making the payments as promised?" And this is from T. Lee.
All right. Well, first, let's back up a little bit because, the first mistake is not getting an agreement in writing, right? So, if you're separated, I don't know if they've actually gone through the divorce process or not. But in those cases, you want to make sure that the agreement is not only in writing, but done properly. So, when it comes to equitable distribution, when you're dividing up assets, sometimes it can be tough because one party may want to keep the asset and one party may want to keep the debt, or may be responsible for the debt rather. And so in this case, the husband's driving the car, it sounds like, but the wife is on the loan for the car. Maybe the sole person on the loan for the car. So typically you always want the asset and debt to be in the same person's name, right? Because you don't want to give away the asset and you're responsible for the debt, which is what happened here. So if I was doing this divorce in this case here, let's say that was the only issue, right? The only issue was the car. The best way to do that would be to have the husband pay the amount of the monthly payment for the car as alimony, and then the wife pay the car loan directly. And obviously that prevents him from not paying the loan and her not knowing about it. And alimony is more enforceable. So it can be enforced by contempt. There can be consequences for not paying alimony. So you have a stronger ability to enforce that provision in court. Here, it sounds like this was more of a handshake deal. You agree to do it and so on and so forth.
Mm-hmm.
Obviously, that didn't work out very well. Now, the other way you could do is that he promises to pay, and if he's more than 30 days late or 15 days late on the payment, then in the agreement it allows you to take back the car. But it sounds like here they haven't done any of that. So I don't know whose name the car is titled in, and I don't know what stage of the divorce you're in. If it's if the title is in solely your name and you have not filed for divorce yet, there's no court order, then theoretically, you could go pick up the car and take the car, but obviously it's going to lead to some dispute, and ultimately you're probably going to end up in court, and a judge is going to have to make a determination over that dispute. But I think it's kind of a classic example of how doing a little bit of preparation and doing things the right way can actually avoid a lot of headaches down the road, because now obviously your credit's been ruined. You have the situation where he's driving the car around, not paying the loan. You're responsible for the loan, and you don't know what to do. So certainly, I think you need to have a consultation with an attorney to go through more details as far as, are you in the middle of a divorce already? Because if you file for divorce, there are certain administrative orders that go into place that may dictate how this is handled.
Would you tell that person you should go get that car and put it somewhere else, and so he can't drive it, or would you?
It just depends. It just depends, because you have to be careful, because if there's court orders that say otherwise, then you can't do that. So that's where you have to be careful, as well as if the the car's titled solely in his name, then legally speaking, he has the right to the possession of the vehicle.
She's saying it's in her name.
I would assume it is since she's on the loan.
Yeah.
But
what about having her pay the loan? What if she's like, maybe in the short term, maybe you should start paying this loan if you can, obviously, just so it doesn't ruin your credit.
Right. If you can, that's the best idea. Then you can basically go after him for reimbursement of that expense, because obviously the damage to your credit, depending on what you're doing in life and the things that you need to do, could be much more damaging than the money, essentially.
All right, we got to take a break, Mo.
All right,
we're gonna take a break, but if you got questions, you send them to us at ask@DeWittLaw.com. That's ask@DeWittLaw.com. We are answering all of your questions that affect you living here in Florida, and we will be right back. Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. We are talking about all of Florida's legal issues and how they affect you. I am here with Mo DeWitt of the DeWitt Law Firm. My name is John Bustecker. Mo is answering all of your legal questions. If you have legal questions, send them to ask@DeWittLaw.com. That's ask@DeWittLaw.com. You can also call the DeWitt Law Firm at 1-800-DeWitt-Law. That's 1-800-DeWitt-Law. Or you can go to the website, DeWittLaw.com. Mo, I got lots of questions for you.
All right, let's do it.
I hope you got the answers to them.
We'll find out, won't we?
Oh, we sure will. You know it all, so I think you're going to be okay.
Know about that, but
you are all knowing when it comes to the Florida law.
We'll see.
All right, here we go. So this is no name on this one, but here we go. I was recently told that my lease would not be renewed.
Okay.
I have never missed any rent payments or been late, and when I was asked why, I was not given a reason, but the landlord said she had a list of reasons.
Oh, boy.
So one of the reasons is she claimed that her son played video games too loud in the apartment.
Okay.
And this woman says, I don't even own a video game system. And so she says, I feel the reason is because I actually made requests to have things fixed in and around my apartment. I asked for new carpet. I wanted something done about the termites, and I threatened to call code enforcement. Now my lease is not being renewed. Is there anything I can do?
Well, frankly, we've been seeing this a lot. I think we've had quite a few questions about this. And I think, honestly, just from my perspective, it probably has to do more with the state of the housing market in general, where a lot of these landlords want to get tenants out of their properties and fix up the property a little bit and get a lot more in rent for the property. So, I think that's probably, if I had to guess, that's probably what's going on with a lot of these things. Now, in this situation, it sounds like you may have just upset the landlord and they don't want you there anymore. And, as long as they're not breaching the terms of their lease, which is the written contract between you and your landlord, and you should check the lease to see what it says. But if your lease is expired, if neither party is given notice that they're renewing the lease, and that there's not an automatic renewal of the lease, then they're within their right to say, we just don't want to renew it. We're going to lease to somebody else. Our contract is up, and that's it. And there's not much you can do about that, as long as they're not being discriminatory and discriminating against a protected class.
And for something like that, they would have to prove it. The renter would have to prove it.
And that can be very tough to prove. So, you'd have to have a whole lawsuit and things like that, but they rented to this person initially. So that's probably a very tough case to show. I mean, it sounds like, maybe the landlord just doesn't think you're a good tenant. Maybe, you made all these requests. They don't want to deal with you. They can find somebody else who will rent the property in the condition it's in for more money or the same money. And that's, well within their right to do.
So if that's the case, I mean, would you at least tell this person, make sure you do save all your correspondence in case there is any issue going forward, or are you just sort of out of luck at this point?
Well, yeah, you should certainly save all your correspondence in case something comes up, as well as when you're moving out of the property. Make sure you take lots of photos and videos, show the condition that the property is in. Hopefully you have those photos or videos when you moved into the property. It's always a good idea to take those as well when you move in to show the current state of the property, and then the property when you move out. So in case they make a claim for your security deposit or claim that there was some sort of damage to the property, you have the evidence to show what it was like when you left.
That's a good point. Coming from somebody who rented for a long time, you always wonder, was that hole in the wall when I first moved in, or did I do that hole in the wall? Right. All right, so that's good advice, Mo.
Or just don't put holes in your wall.
That's true, too. Yeah. All right, next question. My husband and I have not gotten along in years, and I am thinking about a divorce. However, I don't know what I need to prove in order to get a divorce. Are there certain documents I should be gathering? He can be very verbally abusive. Should I try to record these arguments without his knowledge as evidence in the divorce?
All right, so let's break that down one by one. First of all, Florida's a no-fault divorce state. So basically, you don't have to prove anything other than you have there's irreconcilable differences between the parties. Basically, you don't get along anymore. That's grounds enough for the court to grant you a divorce. So, it used to be that you had to actually prove fault, and as crazy as it is, domestic violence was not a ground for proving fault to prove a divorce. So that's why they've gone to the no-fault divorce system now. And basically, as long as you say, hey, we don't get along anymore, the court will grant you the divorce. So there's nothing really that you have to prove there. Now, the question as far as recording the arguments, you have to be very, very careful with that, because in Florida, we are a two-party consent state, meaning if you're going to record audio of somebody, both parties have to consent to it. So you can't take video with audio without somebody's knowledge or consent if you're in an area that had an expectation of privacy.
Like your own home?
Like your own home, exactly. So, if you're trying to secretly record somebody in your own home, you could potentially get into trouble. And, people always throw different, fact patterns at me about that. And it really is a very case-by-case, factually specific scenario, depending where you are in the home, how many people are in the home, if you're inside the home, outside the home, if you're in a public place, a restaurant, whatever it may be. But you just want to be very careful about that. As well as, the court knows that you guys argue. That's why you're getting a divorce.
Yeah.
So there's probably not a lot to be gained there from that type of video. Now, if you are in fear of domestic violence, physical abuse, then there are certain precautions you want to take. Number one, if you can get out of the house, that's the best thing to do always. But you could also put video cameras in the home, but you have to make sure the other party knows that they can see them and that they can record video. Now, there's not the same strict laws when it comes to video recording versus audio recording.
Really?
Yeah, there's just kind of these, I think that's mainly from phone calls is where the two-party consent came from.
Yeah.
But now, obviously, almost every video camera can record audio as well. But there's not the same strict requirement. Now, again, there's still some expectation of privacy. You can't put cameras in bathrooms and stuff like that. But, if you're in fear of domestic violence, number one thing is just get out of the house. If you can get out, go stay with a friend, get an apartment, whatever it can be. A lot of people ask me, well, am I abandoning my home, my rights to the home? No, you're not abandoning your property. There's been this misconception, especially in Florida for some reason, where if you move out of the home, you abandon the property. There's no such thing as abandonment in Florida. It's still your house. It's still a marital asset, assuming it's a marital asset. You're not waiving your right to the property in the home. You're not waiving your right to your share of the home. The court wants to make sure that you're safe and that you keep yourself safe and put yourself in an environment that's safe. So they're not going to punish you for doing that. Same thing when it comes to your kids. A lot of people say, well, then they're going to say I'm abandoning my children. No, you're not abandoning your children. You're putting yourself in a safe position, and maybe you need to put the kids in a safe position as well. But that's a scenario where you should probably talk to an attorney right away. And you may want to file for divorce right away as well to make sure that you can get the court involved and start getting the procedures rolling and make sure the protections are in place.
All right. So if you're just joining us, I'm here with Mo DeWitt. My name is John Bustecker. We're answering your listener questions right here on the DeWitt Law Review. If you have those questions, you can send them to ask@dewittlaw.com. That's ask@dewittlaw.com. You can always visit the website at dewittlaw.com, or you can call 1-800-DeWitt-LAW. I got another question for you, Mo.
All right.
You ready?
Yep.
All right, here we go. My wife has asked for a divorce, and I'm afraid that she is going to seek full custody of my children. I have been a very involved dad, and I'm in fear that she will make false accusations and lie to the court to try to get custody of the kids. How does child custody work in Florida, and what factors do judges consider when determining custody arrangements?
So as we kind of talked about the first segment of the show, child custody or time sharing, as we refer to it in Florida, is made they make a determination as to what's in the best interest of the child or the children. And so usually the judges want the children to spend as much time as possible with each parent, unless there's a reason for them not to. And usually those reasons have to be pretty serious. It has to be, abuse, drug use, mental illness, things along those lines, substance abuse. That's usually what the court's looking at. They're usually not so interested in, mom only feeds the kid peanut butter and jelly sandwiches. I think he needs a more balanced diet. I mean,
There's nothing wrong with PB&Js.
You laugh, but I've had this case before. So, that's usually what they're looking at. But, unfortunately, sometimes in cases, people do raise these allegations of, they may say, mom or dad has a drinking problem. And so then, or a drug problem. And so those are certain things that you have to kind of anticipate. And the easiest way, with drugs, you just go get a drug test, right? Go get a drug test once every 2 weeks, have that ready to go, have it lined up. So when they make those accusations, or if you know they're going to make those accusations, or they have made those accusations, you already have the proof to disprove it. So it speeds things along. Now, the problem is, you would disprove that. Then they say, dad suffers from PTSD. And then now you have to go get that done or this done. Ultimately, though, it's going to come down to, in my opinion, at least, your history as a parent, right? So if you've been substantially involved with the kids over the last 5 years before the divorce, there's never been an issue. There's never been a documented issue of any kind. And you've been, substantially involved while the divorce is pending. And now all of a sudden they're raising these allegations and saying you shouldn't be around the kids. That's a tough argument to make.
Where were you for the last 5 years?
Right. And why is this just a problem now? Why has this never been raised before? So, I think sometimes people lose credibility when they make those arguments, and a lot of times the judges see through it, but the judges also have to be cautious, right? We're dealing with kids here. You want to make sure the kids are protected. So, ultimately it depends what kind of allegations he thinks are going to be made in order, what he has to do to kind of disprove them and be prepared for them.
So speaking of the kids, do the kids ever have any say on how it sort of turns out with the time sharing and who they get to go with and how long they get to go with?
So the kids typically don't get to choose which parent they get to go with, because the kids would choose whichever parent gives them the most candy, right? I mean, so the courts don't really like doing that. Now, there are certain circumstances and certain situations where you can file a motion to allow for child testimony. And those are, the judges really only allow those in very limited circumstances because they don't want to put the kids in the middle of the divorce. And when they do grant that motion in those limited circumstances, the child usually meets with the judge in private with a court reporter. There's not attorneys there. The parents aren't there. And the judge will ask the child questions. And so usually they only allow that, number one, if the child's older, or number two, if the child has some sort of information or has been a witness to something that only they can testify to. And maybe that's, abuse, right? So maybe, one party's alleging that the child was abused by the other parent, and, they can't figure out whether this is real or not. They brought in a guardian ad litem, which is basically an advocate for the child. Maybe the guardian ad litem can't get the information out of the child, or maybe they don't have enough information, or the judge just wants to hear more about it directly from the child. Those are kind of the situations where a motion for child testimony may be appropriate. But again, it's used in very limited circumstances because, ultimately it's not good for, the child at all to have to choose between their parents. It can cause a lot of damage down the road and alienation and things like that.
When it comes to child custody in Florida, and I don't know how it is in other states, but in Florida, do judges sometimes side more with the mom over the dad, or the dad over the mom, or does that not matter in the state of Florida?
Well, historically, I think there was in favor more of the mother, right? So, however, I really don't see that as much anymore. You used to kind of have where dad got every other weekend and mom had all the other time. But I don't see that with the judges anymore. I think they really want to make a determination based on what's in the best interest of the child. Obviously, work schedules and things like that on both parents can come into play. If mom works all the time or dad works all the time, that can certainly impact the time sharing, because the courts typically want the child to spend as much time as possible with each parent rather than a third party caregiver. So if mom or dad's available, they'd rather have the child spend time with mom or dad versus a babysitter or being in daycare or something along those lines. So those are really the things that they're looking at. When you have a parent who's a pilot or a firefighter or kind of has a little bit of a crazy schedule, sometimes those can be more difficult. It's not something that can't be handled or managed. You just have to be a little more creative in the way you craft that schedule to make sure that the parties are getting as close to equal time sharing as possible. Again, assuming that that's in the best interest of the child.
You sort of touched on this earlier, but if you think your spouse is going to make false accusations, I mean, once again, do you just start writing everything down, or how do you sort of document that to say, look, like, this is not true? And do you just have, like you said, take drug tests? And
well, it depends what the false accusations are going to be, right? So, if it's just gathering the evidence, whether it could be through a journal, a diary, you could write down, because by the time you get to trial in a divorce, it may be 2 or 3 years later. So that way you have your notes. It may be, let's say one party's withholding time sharing, saying you can't see your kid. So you're going to document basically every single day that you emailed them or text message them and say, hey, I'm available to come pick up the kid. I want to pick them up. And you're going to write that down in your calendar, and that's going to be your documentation.
All right, Mo, we got to take a little bit of a break. If you got questions, send them to us at ask@DeWittLaw.com. We will see you in just a couple minutes. Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. We are talking about all of Florida's legal issues and how they affect you. I am John Bustegger. I'm here with Mo DeWitt of the DeWitt Law Firm. Mo is answering those legal questions because he knows all about Florida legal issues. If you have questions, send them to us at ask@DeWittLaw.com. That's ask@DeWittLaw.com. You can also call 1-800-DeWitt-Law or visit DeWittLaw.com. Mo, I got one more question for you.
All right. Hopefully we got time.
All right, you're ready. It's a long question, but stick with me here.
All right.
I'm currently going through a divorce with my wife, who I have been married to for 5 years. I have a lot of assets coming into the. I had a lot of assets coming into the divorce, but put most of those assets in both of our names. My attorney is telling me that I can only get 50% of the assets. I don't think this is fair given the amount that I put in prior to the marriage. Can you tell me if there is a way to get more than 50% of the assets, since I came into the marriage with most of them? Also, think about that, Mo. Also, can you tell me what are some common issues that arise in property division during divorce proceedings in Florida, and how can they be resolved?
Well, we could have spent the whole hour on this question. But we'll start from the beginning and see how much time we have to get through it. So, as we've talked about a lot on this show, basically anything that's acquired during the marriage is split 50-50, typically in most cases. There are certain exceptions to that, such as inheritance and things like that. Now, if you come into the marriage with assets, typically those are premarital or non-marital assets. However, if you add the other party's name on it, typically it's considered a gift to the other party, meaning they're entitled to half of that. There is one very kind of small and limited and not very well known exception to that, where if you could show that you solely did it for estate planning purposes, but it's very difficult to show that. It's only happened in a couple cases, but there is some case law out there that supports it. But otherwise, basically, the court's most likely going to find that you added your new spouse's or soon-to-be ex-spouse's name on these assets, and now they're basically marital. And we've warned people about this before, where even if you receive an inheritance while you're married, you want to put that into a separate account that only has your name on it. I mean, I've had cases before where they receive the inheritance in a joint account and then immediately move it into a separate account. And I think most courts would uphold that that's still a non-marital asset. It still opened the door for the other side to argue it. And so then they argued, well, it passed through, and so it should be, half of it should be mine now. Well, you can trace those funds, so most courts aren't going to do that because it is a court of equity, a court of fairness, and they don't want to do that. But
I would assume most of this is like a house, like coming into a
Right,
marriage.
yeah.
Like I had a house and then we got married and now it's our house because
Right.
I put you or whoever on the
deed, yeah.
on the deed. So I assume mostly this is like property.
Mostly it's property, but it could be investment accounts as well. Or, you could add your spouse's name to your investment account. So that maybe you did it so that they would have access to it, or if something happened to you, again, that would be the estate planning exception. So if they happened to you, they would have, the ability to access it. But you could have also started putting, you could have added their name and then put marital funds in it, and now you've commingled it. And so that can create even more of a mess there. So you can kind of see how this can get complicated pretty quickly, especially when you're dealing with a lot of assets that were acquired prior to the marriage and a lot of assets that were acquired during the marriage. It's not impossible to kind of carve some of them out, but it does take some time and some financial expertise to look at it and see, okay, what have you truly commingled? What can we trace? And what is truly a premarital asset versus what is now going to be considered marital.
So I'm gonna ask you then, Mo. Let's say I did have a house in my name. I got married.
Mm-hmm.
It didn't go so well. I'm getting divorced. I had put it in both of our names. Should I have just not done that? What would your advice have been? You should have just kept that house in your name.
Yeah, typically the best advice is to keep that house solely in your name. Now, your wife is still entitled to one half of the appreciation of the home over the course of the marriage, but the kind of the initial investment of the home, the purchase price, whatever you had into it before the marriage, that's still going to be considered premarital or non-marital property.
And that's how a judge would look at it. He or she would look at sort of what was there before. And
exactly. So that's what we call the CAW formula, which is based on case law. It's the CAW case. And that's essentially how the court analyzed it.
Okay. All right. Well, that is good advice, Mo.
That's what we're here for. So, any legal questions, you can always email us, ask@DeWittLaw.com, or you can leave us a voicemail at 407-536-6737.
Man, you know those like right off the top of your
We've
head.
been doing this for a few years now.
Yeah. So if you got any legal questions, send them to Mo DeWitt. He can answer them. Ask@DeWittLaw.com. We are here every Sunday on WDBO at 10 o'clock. Join us next week. And if you like what you hear, you can download some previous episodes on Apple Podcast. Just Google search for DeWitt Law Review, and you can listen to some previous shows and get all up to date on Florida legal issues.
Yep, it's out there on Spotify or wherever you get podcasts from, and you can download it and listen to it in your free time there.
Like I said, go to DeWittLaw.com if you have any more questions or have concerns, or call us at 1-800-DeWitt-LAW. We will see you next week.
So I got a call from a guy last night who was in a pretty bad car accident. He was behind a work truck, essentially. Some items fell off the work truck, went through his windshield, smashed up his windshield, and hurt his hand really bad. So the insurance company reached out to him right after the accident, and he was at first concerned about getting his windshield fixed. I know that doesn't make a whole lot of sense, but his hand was all banged up and really needed to see a doctor about his hand, especially because he does construction work and that's kind of his livelihood. But he was concerned about getting his car fixed, getting it back on the road so he could start driving. So the insurance company sent him some paperwork and he signed it. And the problem is that paperwork was a release. So basically, he released the at-fault party from any and all liability for a little over $400 basically, which means he can never go after them again. So he called us to see if we can help them. Unfortunately, in this case, we can't help him. He released the other side completely, and frankly, there's nothing we can do. And that's why it's always so important that you speak to an attorney before you ever sign any paperwork with the insurance company. Worst case scenario is the attorney's gonna say, yep, you're good to sign it, good to go. Worst case, or best case scenario, it'll save you from something like this. So before you ever sign a release, before you ever sign any paperwork with the insurance company, reach out to an injury attorney. Most injury attorneys won't charge you a dime to talk to you and take a look at that and try to help you with it. Unfortunately for this individual, it's a little too late, but hopefully somebody else out there can learn from his story and hopefully avoid making the same mistake he did.